Good morning, everyone. This is the first part of our discussion on RA 8293, or the Intellectual Property Code of the Philippines. The general discussion. First is the intellectual property. The intellectual property are those property rights which results from the physical manifestation of an original thought. Meaning, if the thing or the subject matter is not an original creation, then it shall not be covered by the Intellectual Property Code. So the following are the coverage of the IPC. Intellectual property rights consist of the following: copyrights and related rights, trademarks and service marks, geographic indications, industrial designs, patents, layout designs of integrated circuits, or those also known as topographies, and lastly, protection of undisclosed information. Under the Intellectual Property Code, we have the so-called state policy with respect to the intellectual property rights. Accordingly, there is a declaration of state policy that the state recognizes that an effective intellectual and industrial property system is vital to the development of domestic and creative activity. It likewise facilitates transfer of technology, attracts foreign investment, and ensures market access for our products. Hence, it shall protect and secure exclusive rights of scientists, inventors, artists, and other gifted citizens to their intellectual property and creations. We have the so-called International Convention and Reciprocity. Under this doctrine, any person who is a national or who is domiciled or one who has a real and effective industrial establishment in a country, which one is a party to any convention, treaty, or agreement relating to intellectual property rights or the repression of unfair competition to which the Philippines is also a party, or one that extends reciprocal rights to nationals of the Philippines by law, shall take note of the following: shall be entitled to the benefits to the extent necessary to give effect to any provision of such convention, treaty, or reciprocal law. In addition to these rights, there may likewise be other intellectual property rights. Under the reverse reciprocity of foreign laws, under Section 231, this is the making enforceable on nationals of a foreign state all conditions, restrictions, limitations, diminutions, requirements, or penalties that may be imposed by such foreign state on a Filipino national seeking intellectual property protection. In layman's term, ang ibig sabihin lang nitong reciprocity rule under the Intellectual Property Code: if country A, there is a Filipino residing therein, and they are a party to the international convention which recognizes the intellectual property rights, then the same protection shall be extended to their nationals that is within our or that are residing in our country. So kung ano ang i-extend nilang protection doon sa ating nationals in their country, the same protection shall likewise be extended to their nationals na andito sa country natin. Of course, take note that the countries must be parties to the convention. We have this so-called technology transfer arrangement. What is this kind of arrangement? Contracts or agreements involving the transfer of systematic knowledge for the manufacture of a product, the application of a process or rendering of a service, including management contract. And it is the transfer, assignment, or licensing of all forms of intellectual property rights, including licensing of computer software, except of course the computer software developed for mass market. Under the Intellectual Property Code, it provided a prescriptive period of action for damages. According to Intellectual Property Code, no damages may be recovered after 4 years from the time the cause of action arose. Meaning, if your intellectual property right is violated, you are given by the code a period of 4 years to enforce your right. Next is the jurisdiction over the disputes under the Intellectual Property Code. First, we have the so-called original jurisdiction. Original jurisdiction meaning kanino ka first magfa-file ng complaint mo? Sino ang unang lalapitan mong opisina? First, we have the Director General. Director General of the Intellectual Property Office. The Director General has original jurisdiction to resolve disputes relating to the terms of a license involving the author's right to public performance and other communication of his work. Another one is the Bureau of Legal Affairs. The Bureau of Legal Affairs has the jurisdiction over 1. The opposition to application for registration of marks. 2. Cancellation of trademarks. 3. Cancellation of patents, utility models, and industrial designs. 4. The petition for compulsory licensing of patents. And lastly, it has the jurisdiction over administrative complaints for violation of laws involving intellectual property rights where the total damages claimed is not less than 200,000 pesos. Another of